All right, I'd like to welcome our next presenters, Mcguire Boyd and Patrick Haynes, who are both partners in our firm's litigation section and who will discuss how to manage your response to investigations and litigation. Patrick focuses his practice on handling all manner of disputes that arise from business competition and regulation. He serves as co-chair of the White Collar and Investigations team, and his practice has included a broad base of civil and criminal litigation, as well at both the trial and appellate levels. Patrick also serves as an adjunct professor at the University of Richmond School of Law, teaching in the area of white collar crime and investigations. Mcguire is an experienced trial attorney with primary focus on financial services and business disputes. He defends financial services clients against a wide variety of federal and state law claims, including both individual and class action claims. Patrick, I'll turn to you to kick us off.
Well, thank you, Carrie. Good morning to everyone. We are going to dive right into our presentation today, which we have put together to be a scenario-based presentation. So we're going to follow a matter that begins in my area of expertise and then proceeds forward through the facts. I'm going to talk about what happens at the initiation of an investigation of possible serious wrongdoing at a fictional company. Mcguire is going to take over and pick up where civil litigation arises out of the same scenario and talk about a framework for how our fictional company would handle this litigation with its counsel. So here we begin. An anonymous caller over the Arwalt Corporation hotline alleges that a senior vice president in the finance department of the company's largest operating subsidiary, which is Arwalt Drilling, instructed its employees to create false and backdated invoices to support payments to a third party whose name is not on a list of known and approved vendors for the company. The anonymous report includes a limited number of examples, which are attached, of the allegedly altered documents. The conduct allegedly has been occurring since 2015. The anonymous caller claims to know that the payments are somehow tied to a consultant, an LLC, controlled by the spouse of a high-level procurement official in the Department of the Interior, who's responsible for buying drilling guidance equipment for the company. The caller also claims the chief business executive of the subsidiary found out about the payments in 2018, but the falsification of invoices did not stop.
Patrick, ouch. This is a tough day for the company. What do they do?
Well, it could be. It could be. Let's first do a poll. We're doing our poll, which kind of will set up for some of the questions that we confront at this part of the scenario. So the question is, if the allegations prove to be true, and if the conduct of Arwalt employees violated criminal law, who or what entities are exposed to criminal prosecution? Before I address individually the different options that we had here, Mcguire, this is the first consideration that the company wants to make sure it's clear on, is who is exposed. The vicarious liability concepts here, ultimately under U.S. criminal law, are the same as in civil law. Which is that a company, an organization, is vicariously liable for the wrongful conduct of its employees as long as they're acting within the scope of their job duties. It does not matter whether that is a criminal matter or a civil matter. And that's been the law since the Supreme Court ruled at the beginning of the 20th century in a case called New York Central Railway. And we'll talk a little bit about the different possibilities here. Answer A, only the employee, is not right because of vicarious liability concepts. Arwalt Drilling is who the employees in this case work for. So if the allegations prove to be correct, then Arwalt Drilling and the employee would both be liable. A lot of the people listening also said the parent company, Arwalt, would be liable under these allegations. But actually, I think the accurate answer is answer D, because, excuse me, I'm sorry, not answer D. Answer C is not correct because on the facts we have so far, we don't have control of the activity alleged by anyone with the parent company. And so the same concepts of control count, it's not sufficient just that the subsidiary is 100% wholly owned by the parent company. If no one at the parent company directed the wrongful activity and were early on in the scenario or participated in it, then the parent technically would not be liable, but this is subsidiary employing the employees would. Answer D is also incorrect, and we'll circle back around to this when we talk some about corporate policies, but it does not depend on the fact of whether Arwalt or Arwalt Drilling have policies that prohibit the conduct. Now, moving on to sort of more of the practical considerations at this point in the very early on in the allegation. The kinds of things that the company and its inside counsel need to confront at the outside. And if we can stop sharing the question just to bring that down, who to inform within the company when this allegation has come in. We have to consider the need for leadership of Arwalt to be apprised about serious potential threats to the business. There are a whole host of other constituencies that then come into mind. Personnel who are responsible for the operating subsidiary, personnel who are responsible for accounting, internal audit functions, compliance if there's a group that handles compliance. So initial considerations are going to certainly focus on who do we need to tell about this? Who do we need to talk to about it? Whether to investigate the allegations at all is not an unreasonable question for someone in the company to ask, but of course the answer is yes. You always want to know and run towards the fire to try to determine whether the situation is as dire as it potentially is from looking at this. So once you've reached that relatively easy decision under these facts, you have to determine who's going to conduct the investigation. Are attorneys going to be used? Are there other resources, accounting personnel, internal audit personnel, other persons who work inside the company, but also the potential of bringing in consultants and experts from outside of the company to participate in the investigation team. An important determination there, or factor in the determination, is the desire to keep the investigation under the protection of privilege and work product protections. The presumption in cases throughout the country is that a investigation conducted by outside counsel, counsel who are not employed by an entity or by a company, is presumptively going to be privileged. If the investigation is conducted by in-house counsel and in-house resources, the company still has would have the burden to prove that a legal matter was being investigated under the attorney-client rubric. So the presumption doesn't exist there. We'd have to consider document retention and suspension orders. When is the appropriate time? Is under the facts of this mere allegation, does it reach that level? And I know, Mcguire, you were going to touch a little bit on document retention and when document holds become necessary later on in the presentation. How are we going to maintain confidentiality in a large organization if we start to ask questions and interview employees and obtain documents about these allegations? How is the company going to confront those types of issues with its own employees? And then, of course, the company has to consider the consequences of investigating this matter and its possible outcomes with respect to potential civil liability and what duties it owes its shareholders, particularly if it's a public company. So it might be bad, getting back to your question, Mcguire, but we really need to move on and start to investigate the matter and try to find out what the facts are. Can you turn to the next slide? So managing the investigation. The company has decided in this case, Arwalt, to hire outside investigating counsel to investigate these serious allegations. So investigating counsel develops key parts of an investigation work plan. General counsel confronts privilege concerns with this investigating counsel. And issues described in those initial meetings implicate various technical and legal challenges in obtaining and reviewing documents from around the company.
So, Patrick, what do you do to keep all of this work product from being out in the open a couple years down the road?
Well, the way you do it is by being very cautious at the outset and making sure that everyone is clear about how to, inside of the company or is participating in the investigation, is clear on what the expectations are to maintain privilege. And it's critical that this is done at the outset and in this meeting with general counsel and investigating counsel. And the reason is these communications are going to necessarily require working with people inside of the company, talking to people inside of the company, and many of those people may not be used to maintaining privilege and what is necessary to do that. They need to be directed specifically who and how to communicate their findings if they're asked to go out and get information and bring it back to counsel. That's critically important. Having delegation memos and letters and emails that memorialize the instructions being given to them is very important. And as long as you do that at the beginning of the investigation in an appropriate way, you're signaling what you need to do to protect the privilege in these circumstances. Let me ask to go on to the next slide, where we talk about privilege. One of the issues highlighted here are the privilege issues that you asked about, Mcguire. There are other key issues that we need to talk through at this point in the investigation, once we have actually launched an internal investigation. The scenario slide mentioned work plans and budgets. There is absolutely nothing inappropriate with having an internal investigation, just as with any other legal matter, having a budget, having a scope that's agreed on between outside counsel and the company. Not every investigation is Watergate. On the other hand, you want to make clear that if it's a serious investigation, that the resources are there and that everyone is clear on the scope of what is going to be looked at. And the way to do that is in the work plan. Now, work plans can change during an investigation. They often do. But having at the outset a plan that says what documents will be obtained, what files will be obtained, what they will be looked into for, what resources will be involved, and who will be interviewed is very important and gives a roadmap to the rest of the work that's going to be done here. A key part of this is going to be the collection and management of documents and other electronically stored information. that is, as a matter of fact, going to be such a dominant part of at least the beginning of a work in an investigation like this, and is going to pose numerous challenges, both technical challenges, potential challenges if data and information is sought from other jurisdictions, where privacy laws are vary a great deal. It's going to involve data privacy rights of employees and of third parties and how they have to be respected. Finally, the role of experts and consultants assisting in the company's investigation. Again, a key part of budgeting and planning in this is, do we need to have an outside accounting firm assist us in auditing these records that are going to be looked at? Does the company have internal resources to handle the kind of data review and extraction that's going to be necessary, or is this really outside of Arwalt's technological capabilities, where we'll have to bring in IT company? So that's important to do at the outset of the investigation as well. Really what we're talking about here is management, and that's key. Both the general counsel and investigating counsel have to manage the team of internal and external resources that are best to investigate this matter, and they have to manage the expectations that the company has and what the investigation team have about how to move forward in it. And there are numerous examples of where those expectations get out of whack and cause discord in an investigation that's just harmful to its outcome. If any of you are familiar with Walmart's internal investigation that ultimately ended up on the front page of the New York Times in the 2000s, as much of the problem in the initiation of that matter's internal investigation was how the expectations of the company and its personnel and the expectations of the outside lawyers that initially brought on just got out of kilter at the beginning and created major problems for the company. If we can go on to the next slide. So the investigation team in our case begins conducting the document reviews. The team provides general counsel and the chair of the audit committee with regular updates. After some investigation, the team has identified several suspect transactions that have become the focus of this investigation, totaling more than $1 million. None of these transactions appear to have been for the purposes that were described in the subsidiary's general ledger, which rolls up into the financial statements of this public company. In the course of this internal investigation, there are, as we can tell, it's getting more serious. And at this point, the investigation has certainly found some possible wrongdoing. And in the course of reviewing documents, identify documents that look quite bad, including this next one. If we can switch the slide. This is a memo to the senior vice president of finance from that is copied to the CEO and the sales director. And in the body of the memo is item number 6, dummy invoices for the special fees. I completed backdating and booking the dummy invoices. I put them under sales commissions for now, although I'm pretty sure we'll get questions about that from our auditors. We need to come up with a better cover story to explain them. If they are supposed to be some kind of official charge, such as a notary, why don't we ask the vendor to provide us with something that would pass muster? Okay, so this is the hot document, also the bad document, also the hot potato. So plainly, we have found something serious here, potentially corroborating the initial allegation. Can we move on to the next slide? So where we're going to go in our scenario after we complete our analysis and review of documents is to needing to sit down and talk with persons knowledgeable about what we're seeing. So as our scenario continues to that part of the investigation team has asked general counsel to assist in requesting and arranging for investigation interviews of some of the more senior personnel. Right after general counsel is part of a communication to Warren Buffett, the CEO of our company and one of the recipients of that bad document that occurred with outside counsel on the phone, immediately after, the GC quickly receives a call back from Buffett without outside counsel on the line. Buffett asks to confirm his understanding that whatever he discloses during the interview will be confidential and privileged, quote, company information, end quote. He also asks if he should have his own personal attorney attend the interview and if the company will reimburse him for his personal attorney's fees. So now we have our second poll. Are the statements Buffett makes during the interview, not legally privileged at all, B, fully within Buffett's attorney-client privilege, C, privileged, but it's Arwalt's privilege, and it can waive that privilege without Buffett's agreement, or D, it may depend on what response Buffett is given to his question. Mcguire, what's your guess? Which answer did you give?
I'm going to go with the highest percentage, Patrick.
With the percentage answer. Okay. All right. So A, not legally privileged is wrong. If we keep the interview confidential and with the company's control group, which certainly should be in our intent and was part of our work plan. B, fully within Buffett's attorney-client privilege is wrong because we are counsel for Arwalt Drilling Company and the parent company, not for Buffett. C, which got the most answers, is right so long as we give an appropriate answer to Warren Buffett's question. And I want to explain that. So D is the most right answer, because if we answer his question wrong or don't give him an effective upjohn warning, then he may claim that he believed the statements are personally privileged. So let me go to the next slide and talk about these the issues that come up here with the employee interviews. There's always an issue of timing and the basic logistics of interviews, who attends and participates, where to do them, whether it's best to do them at the corporate office, offsite, or now with Zoom capabilities. There are going to be issues unique to interviewing potential targets and the whistleblower, if we believe we know who it is within the company who made this report. The question of individual representation by attorneys came up in our scenario, and it comes up from time to time, certainly in these matters. And that's a very broad topic to get into, but it's something that our company, Arwalt, would need to have prepared with how it's going to handle it before it requests these interviews, because that question is going to come up. Some employees are going to ask, as Mr. Buffett did, whether their fees for individual counsel will be indemnified by the company. Upjohn warnings, which is what I suggested is determinative of the right answer to our poll, is simply making sure to give the employee that you're interviewing a clear explanation of who you represent, i.e. the company, not the individual attorney, that the privilege belongs to the company, not to the individual, and that the company can choose to waive that privilege and share the information should it choose to do so. And again, that's critically important to give. There are different ways to give it in an employee interview. and I won't go into all of those options, but the ramifications are important. And there have been cases, important cases determined where courts held that the company and the government, once it received the information through the company's lawyers, could not use that information because an employee or an officer in most cases reasonably believed that the lawyers interviewing him were also representing him or her individually. Let's move to the next slide. Outside counsel and the examiner consultants are going to begin to confront questions regarding the fact that some of you may have noticed in the scenario that these suspect payments appear to have been made for several years without detection by internal audit or by outside auditors doing their work every year. The company does have a long-standing written policy prohibiting bribes and gratuities in broad language and obtains annual certifications from management personnel that they understand that policy and agree to follow it. However, our company has never instituted before any formal training program and does not have a dedicated chief compliance officer. If you can move to the next slide, please. Internal controls and compliance issues are critically important because they are going to be important on this company's response, both to the government potentially, to individual shareholders, and in the context of civil liability. These are major considerations in all of those situations, both with the regulators, with shareholders, with directors, of course, who have to be concerned about their own potential liability, given how long the conduct happened without detection. And so they're critically important questions to answer during an investigation, including answering the root cause. What was the root cause that allowed or promoted or encouraged the conduct to continue? Whether it be profit motive, culture of the company, promoting profit above other considerations, failures of supervision, whatever they are, they're going to be very important for the company to learn those answers. We mentioned corporate policies, and that was part of one of our poll questions earlier. While it's good that our company has a corporate policy prohibiting the conduct, it's not enough, and it's not enough to avoid liability of the company. That is the rule of the basic construction case in the Fourth Circuit, and connects with that earlier question about corporate liability. A company cannot be exonerated just by the fact that it told its employees not to violate the law. Now, let's go to the next slide. The investigation team is concluded here and gives its report to the audit committee on its finding. The investigation has discovered evidence that the $2 million now in suspect payments were fraudulent. The team identifies a number of criminal statutes and securities law violations that are implicated by the conduct, and determines that the senior vice president of finance directly controlled it, and the chief business executive, the CEO, Warren Buffett, knowingly tolerated it. So, investigation over.
Patrick, that's great. We can just put a lid on this, right? Lessons learned, move on.
Right. Unfortunately, no. And the company has to decide in this situation whether to self-report the violations to regulators, and if not to do that, what other steps it should take as remediation, both to prevent future conduct from happening and to be prepared if an investigation does come down the path at some point. Determining whether a self-report is obviously a really critical step in this investigation, because the decision is one that can lead to significant mitigation of harm with the government. And in fact, The government later finds out about conduct the company learned about but didn't report itself under DOJ policies that will result in much harder treatment. And as a matter of fact, it's a carrot and stick approach, of course. If you do self-report and under other circumstances that are defined in DOJ policies, the company might be able to escape all punishment other than disgorgement of profits and taking appropriate remedial actions. So self-reporting is a critical decision, which there's too many factors to go into this of when companies determine to do it and when they don't. If you can go to the next slide, some of the considerations at the end of this investigation tie to that, whether we've done a written report or an oral report. If you've done a written report and the company does decide to self-report, the government's probably going to want to see that report, which also creates issues potentially down the road with respect to any civil litigation. Outside auditors have to be informed and have a role in potential ways of affecting the company's decision because of what outside auditors' obligations are once they are informed of this kind of wrongdoing. The cooperation credit is part of the cost-benefit analysis. What credit the government will give the company in terms of a reduction of its ultimate fine and other impacts is a critical part of the cost-benefit analysis, and trying to quantify what those benefits might be is going to be a key part of our discussions with the board. Terminations of employees who were involved and other remedial steps, such as enhancing the this company's compliance structure, program, and format, are all things that the company is going to need to confront and that are affected frankly, by the decision. Are you going to self-report, or are you going to try to deal with these issues internally and with an eye towards potentially having to justify what you did down the road? Finally, if we are going to self-report, we have to prepare for parallel proceedings, possibility of enforcement agencies, multiple enforcement agencies, all investigating a matter at the same time, and how the company wants to try to manage those things. Or even if there's an international aspect, if there are investigations by different countries with overlapping jurisdiction over the wrongdoing. So let's go to the next slide. In our case, Arwalt did decide to self-report to obtain the most cooperation credit that it can obtain. Outside counsel notified the federal law enforcement personnel with jurisdiction to prosecute violations of the laws that were implicated in the conduct. Inside and outside counsel have met with the government, provided a timetable, summary about the investigation, shared what key employees said during their interviews. And no surprise, as a result, the government opens its own formal investigation, issues subpoenas to the company, involved employees, and the company's outside auditor, and requests the company make several of its employees available for interviews. The company also timely, because it's a public company, the parent company, timely files an 8K disclosing the existence of the government investigation. And within 2 weeks, shareholders file a securities fraud lawsuit against the company and its directors for material misrepresentations and omissions. All right, Mcguire, now civil lawsuit has been filed. Where do we go from here?
Thanks, Patrick. The next portion of the slides that we're going to go through, I'm going to discuss a checklist approach that you could take as in-house counsel to a securities fraud lawsuit, or really any type of lawsuit. I'm not going to dwell on the hypothetical merits of a securities fraud lawsuit here. I'm going to go through a checklist that should be amenable to almost any type of lawsuit that comes through the door. For in-house counsel who've had prior litigation, private practice, some of this will just be very basic blocking and tackling. And depending on your management style, your litigation management style, you may rely on outside counsel to handle almost all of these decisions. The important part is to at least be involved in these decisions because they will impact the outcome of the litigation down the road, and having some version of a checklist is handy. It makes the process more manageable. I've kind of put this in what is a triage format for me. You may flip some of these questions around, but for me, the first question is always, is the clock running? The surprisingly simple but sometimes complicated question: have we been served with both a complaint and a summons? That's what it takes to get a clock running. In my practice representing financial services companies, they get hit all the time with courtesy copies of complaints by email, maybe by certified mail rather. The important part here is to start investigating if you've been hit with a courtesy copy, but definitely know when the clock has started to run. Part of that question is understanding whether the method of service was proper. Generally, on a domestic company or even an out-of-state company, it's got to be service on a registered agent or an officer or a director. It can get even more complicated if service is on someone else, maybe a receptionist who scans the documents into a company's central core system. Has the company been served in that instance? That's a harder question based on this Virginia Code section I've cited, 801-288, which says process which has reached the person to whom it is directed within the time prescribed by law shall be deemed sufficient, though not served or accepted as provided in this chapter. So that can cause a great amount of uncertainty. Let's go to a poll question. So this is a hypothetical. A summons return shows service on a company's high-ranking employee, but not an officer or a director, at the company's principal office. No answer is filed. On a motion for default judgment against the company, should the court decide that the company was properly served, so a default judgment should be entered, improperly served, but still had time to respond, improperly served, but because it now has actual notice, it should respond within 21 days, or improperly served, and therefore the court has no personal jurisdiction over the company and cannot enter a default judgment against it. Cited 801-288, which says process which has reached the person to whom it is directed within the time prescribed by law shall be deemed sufficient, though not served or accepted as provided in this chapter. So that can cause a great amount of uncertainty. Let's go to a poll question. So this is a hypothetical. A summons return shows service on a company's high-ranking employee, but not an officer or a director, at the company's principal office. No answer is filed. On a motion for default judgment against the company, should the court decide that the company was properly served, so a default judgment should be entered, improperly served, but still had time to respond, improperly served, but because it now has actual notice, it should respond within 21 days, or improperly served, and therefore the court has no personal jurisdiction over the company and cannot enter a default judgment against it. I think the right answer here is the last one, D, improperly served, therefore the court has no personal jurisdiction over the company. That's the result that the Western District of Virginia reached in a recent case that I took this hypothetical from, but I want to point out that it was not a black and white issue. The company trying to get out from under default judgment had to submit affidavits saying that this high-ranking employee received the complaint, sat on it, and that no leadership of the company even was aware of the complaint. Now, those facts in the form of an affidavit cause the judge to relieve that company from default. That may not always happen. Said differently, method of service is not a good defense. You really should, if you're uncertain about whether you've been served, reach out to the plaintiff's counsel and just negotiate some sort of extension. Next slide, please. Once we know we've been served or accepted service, what's the response deadline? It's going to be 21 days in state or federal from service, or if you've waived service through a request, 60 days. An early question you need to ask is, are we in the right forum? Have we conducted any business in the state where we were sued? Where are the important witnesses? Where is the evidence? Can we remove to federal court, or do we belong in federal court? These are procedural issues that have to be confronted quickly in responding to any type of lawsuit. Different considerations of state versus federal pertinent to Virginia a lot of times have to do with the availability of summary judgment. The Virginia Code changed in the last couple of years to allow between businesses when the amount in controversy is above $50,000, the availability of deposition transcripts on summary judgment is a new concept in Virginia. Still, though, if you have good facts in your defense and you want to get those facts out in discovery and in front of the judge, your better bet is federal court, because district court judges are just more prepared to grant summary judgment.
Okay, Mcguire. So we know that we have some bad facts here, and and going beyond some of the procedural, questions. This lawsuit involves some potentially very bad news for the company, with potentially a lot of business impacts. So, how do you think the company and its outside counsel should go about having these conversations and kind of proceed with a strategy for the case?
Well, I think if we go to the next slide, it looks like a master of the obvious question, but it often does not get dug into deeply enough early enough. We can get very tangled up in the procedural questions that I just went through, service, forum, but we need to have real substantive, honest conversations about what this case is about. What is driving it? Is there a personal dynamic, a vendetta, or is it misrepresentation? I'm talking about just any type of lawsuit, not necessarily a securities fraud claim. Does the lawsuit stem from a misunderstanding? Does it stem from a business competitor's sharp practice? Finding out what this case is about. What is the company's liability? What is the company's overall exposure? A different way of asking about exposure is, what does the plaintiff's best day in court look like? These are questions that really need to come out early, even though you haven't had discovery. All you have are the allegations and then whatever you can glean from your own internal investigation. The company's overall exposure is comprised of, these are just 8 different concepts, but we've got damages to worry about. Is there an attorney's fee provision by statute or by contract that's going to shift attorney's fees to a prevailing plaintiff? What are defense costs going to look like? Could the company be subject to a court-issued declaration or an injunction that just tanks its business? Could the company be forced to disgorge profits? Could a contract get rescinded that creates precedent for the rest of the business? And then what's the reputational risk? These are all questions that need to be asked really early. And they're not always comfortable questions. A lot of times, the business has gone one way. In-house counsel finds out about it late. Outside counsel's brought in. These can be very tense questions that we kind of want to avoid, but failing to ask them up front can really cause trouble down the road, especially when the litigation hits crunch time. We need to be preparing for depositions. We need to be preparing for trial. Questions that fall in this category are, is our company's core business at stake? Are core principles at stake? And then, what is our risk for the pain and the distraction of carrying on our core business while we're defending this litigation? These are tough questions that need to be addressed up front. Next slide, please. Another consideration is, do we have capable witnesses? Do we have anybody who, for whom this is going to be their first rodeo, and we just don't know how they're going to hold up throughout depositions or on the stand? Against the plaintiff, do we have any counterclaims? In state court, you have a little bit more room to get those counterclaims out. In federal court, you could be stuck with having to get that counterclaim filed as soon as you file your answer under the compulsory counterclaim rule. A question that Patrick touched on in his discussion has to do with litigation holds and having one in place. This is another question that needs to come up very quickly as soon as you know about the lawsuit. There are a series of questions to ask in connection with litigation holds. Can we go to the next slide? And I know I'm moving fast. We're a little bit constrained for time, but I want to focus on the last two questions on this slide. Is any potentially relevant information hosted by a third party? And who's in charge of overseeing and coordinating this collection? Somebody has to be. Otherwise we wind up 10 months down the road and we're not sure who is responsible for what. That's a very stressful place to be in litigation when discovery requests are coming in from the other side. Let's go to a poll question and having one in place. This is another question that needs to come up very quickly as soon as you know about the lawsuit. There are a series of questions to ask in connection with litigation holds. Can we go to the next slide? And I know I'm moving fast. We're a little bit constrained for time, but I want to focus on the last two questions on this slide. Is any potentially relevant information hosted by a third party? And who's in charge of overseeing and coordinating this collection? Somebody has to be. Otherwise we wind up 10 months down the road and we're not sure who is responsible for what. That's a very stressful place to be in litigation when discovery requests are coming in from the other side. Let's go to a poll question. Okay. In this scenario, a parent company has been sued. The subsidiary has no employees, no computers, no data servers, no email archives. Does the subsidiary still need to issue a litigation hold?
This one, the answers are very close, Mcguire.
And on my screen, I can't read the entire, oh, I can if I hover over it. Let's see, it looks like most of the audience has had time to answer. I really want the answer to be A, no, not under these circumstances. But that's not how it works. I think the right answer is always going to be D. The company needs to reach out to any affiliate, any parent that hosts documents, electronically stored information that company uses. Between affiliates, between sibling corporations, if there's any commonality of ownership, if there's any overlap of officers and directors, if there's any extent to which information is exchanged between those companies, the company that got sued can't just silo itself and say, I have no responsive documents. It has to reach out to its affiliates. Next slide.
And it's worth thinking about. At this point, you're talking about the hold as opposed to actually searching and producing documents, right? So correct. Is it sort of a case of better safe than sorry here at the outset?
Yeah, the hold needs to be implemented no matter how intrusive it is. If you don't have that hold in place across the family of companies that share this information, the pressure points down the road are going to be severe.
Okay.
Another key question that has to come up, from a triage standpoint, you might throw this one at the very beginning, is do we have the financial resources to defend this litigation? A component of that is, do we have any insurance coverage that applies? Does that insurance coverage impact our selection of counsel? And then what are our likely defense costs? Outside counsel can get you an estimate of these various areas up front, but that estimate can get out of whack quickly. It needs to be revisited and tightened as the litigation progresses. Next slide, please. Do we need experts? Testifying experts, possibly, but oftentimes a company will need a consulting expert, someone who's just got the subject matter expertise to help drive the strategy. Important part here is to understand that ordinarily the other side cannot get discovery of the work of your consulting expert who's not expected to testify. There's a case I located, the Scott Chipotle Mexican Grill case, which gives you some notice of a possible exception when in-house counsel hires a consulting expert and there's an exchange of information. A lot of times it may not be for the purpose of legal advice. It may be for business strategy, marketing, anything like that. And that can get discoverable. With consulting experts, it's important to have your outside counsel hire that consulting expert. Always include outside counsel on the communication, and you can throw in the subject line attorney work product and secure better protection. Next slide, please. All right, quickly, corporate depositions. I put this slide in this deck just because it's one of the more stressful, expensive parts of litigation. It's because the other side can send you a notice. It can list a ton of topics, and the company has a duty to put forward a witness, a designee for each of those topics if they're described with reasonable particularity. There's a lot of fighting prior to a deposition between attorneys over whether a topic's been described with enough reasonable particularity. For example, if a topic includes the phrase, any and all information or documents related to X, Y, and Z, well, how does the company prepare its designated witness with such an unbounded description of the topic? The topic has to be constrained. The boundaries of that topic have to be known going into the deposition, and that's frequently, entails a lot of negotiation with opposing counsel, and sometimes it entails having to file a protective order and having to file a motion for protective order in court just to get the scope of the deposition narrowed. The stressful part about a corporate deposition is that the company is going to be bound by the testimony of a designee on a particular topic at trial. So, if that designee says something like, "Oh, I don't know," or "I don't remember," that's a really tough answer for a company to have to deal with at trial. Can we go to the next slide, please? Finally, in litigation, like the type of litigation Patrick handed off, a tactic that plaintiffs' counsel often try to do to create leverage is to notice a high-ranking officer within the company. It's called an apex deposition, and they can do that, right towards the end of the discovery cutoff to really cause panic and really get under the skin of the company. The first bullet point up there, the Western District of Virginia case, that's a really good opinion that discusses what that party seeking to depose the high-ranking officer needs to show. The executive has to have some unique knowledge of the facts at issue, and the party seeking his deposition or her deposition must have tried other avenues for obtaining that same information. The next case from the Eastern District of Oklahoma is a good one too, because you may have a high-ranking official or officer in your company who really knows nothing about the facts, but his or her name has appeared in the signature block of every important contract at issue in that case. That was the facts in this energy PetroQuest energy case. And the apex deposition was allowed to move forward because that executive had signed or allowed his signature to be on those documents. Patrick, I think it's back to you now.
Well, it is. The government investigation has not gone away, while Mcguire has very effectively represented Arwalt in the civil case. Attorneys and federal agents have spent 14 months conducting their own formal investigation. And after that, the lead prosecutor from DOJ and the lead enforcement lawyer from the SEC contact Arwalt's outside counsel and inform her that both of them have decided to proceed with charges against Arwalt and some of its executives. They request a meeting to discuss whether the company is interested in reaching a resolution that will require, at a minimum, an admission to felony violations of federal law, payment of substantial fines, and an agreement to take other remedial actions. If we go to the next slide, there are key issues here, and just connecting to what Mcguire has been talking about with our parallel investigation, is a key issue here is which to try to resolve first. And we would have started to think about this earlier on, as soon as Mcguire had received and been engaged in the civil case, to try to figure out the different progress of the different matters and how resolving one first might impact the other. There are important strategic determinations to make there, whether to try to get the civil settled first or to get the criminal and enforcement matter settled first, or of course, in a perfect world, would be settling everything at the same time. But those are critical decisions, and there's not one size fits all to what's going to be best for Arwalt or what circumstances it can actually control. Other issues that the company is going to have to confront in these negotiations with the government is the range of the potential resolutions. Prosecution for a crime, deferred prosecution agreements, non-prosecution agreements, or convincing the government to simply decline to pursue this against the company in light of the factors that my counsel are self-reporting, the actions that the company has taken in response, et cetera. There are going to be issues about their prosecuting the individual executives and the reputational and other harms that has on the company, and the effects that has on the company's insurance proceeds, which Mcguire briefly touched on. It's the same pot of money with a certain cap that's likely to help the company both with its civil liability and its criminal liability. So, and with its defense costs of itself and executives who agrees to indemnify. We're going to have to try to advocate for a particular amount of fine that we think is appropriate and for the company to have. SEC action is going to have matching, and in some cases where fines can be credited against from paid to one entity can be credited against another resolution, but not all. So we're going to have to address those issues that are unique to the SEC action. And finally, the potential of having ongoing reporting requirements to the government or to the court under an agreement that involves corporate monitoring, outside monitoring of the company's conduct going forward. So these are all going to be critical questions as we go forward. That is all the time we have today, and we're right at 12 o'clock. If anyone has any questions, we had one question that we didn't answer during the performance. What data privacy rights are triggered if the subject of the investigation is that employee? And that's it's a interesting question. And there are a number of war stories that I would love to tell about that. But that is one of the things you have to determine is who's doing the investigation, who is gathering investigation and has data, and then what rights do they have as well. So unfortunately, given our time, we're going to have to leave it at that.
Thanks, Patrick.
Okay, well, it looks like we're coming up on the end of our time. Thank you for joining us. You are now headed into your break. After the break, you'll hear from Jennifer McLemore and Carrie Stanton, who will discuss legal ethics for corporate counsel beginning at 12:15.